In 3, 2, 1.
Після перерви продовжуємо засідання. І прошу запросити до зали
So we
засідання
are pursuing this session, and let us invite Teslenko Iryna, the next candidate.
Так, а у нас пані Мері.
And Mary,
Показе чи ні?
is she with us?
Yes.
Але ми вас не
Can you
бачимо.
hear me? I'm here.
Ви
I'm
але не
trying to-
бачимо.
We can hear you, but we can't see you.
I know. I'll
can't
change
see you.
devices. Sorry. Okay.
А що у нас зображення?
You waiting for me?
Але ви нас чуєте, так? Все. Готово. Розглядається
We're
питання
done.
щодо відповідності
So the issue of whether this candidate, Teslenko Iryna, is eligible for the participation in the competition, and the Public Council of International Experts are present. Robert, Norman, Mary, Gabrielle, and Gabrielle will not join us today. Is it correct? John J. O'Sullivan, Jessica Lowe Thompson, and High Qualification Commission members are also present. Mikhailo Bogonis,
Людмила Волкова, Віталій Гацелюк,
Людмила Волкова, Дацелюк, Роман Денисюк, Олег Колюш, Ігор Кушнір, Руслан Мельник, Олексій Молян, Роман Сабатаж by video, Сибирович, and we are waiting for one more member to join us, Helena Shevchuk. Is the composition of the commission clear to you? Your rights are to request recusal, provide explanations, and voice your thoughts and considerations, and also ask clarifying questions according to the law. No new materials have been considered, only those that have been submitted within the deadline. And in case there are circumstances that can impact the decision, a decision to include additional materials to the consideration can be taken by more than 3 members. Any recusal or motions, I sent an application about recusal in writing, and whether you still have this request. Yes, I support my application. And because you say that you support your application now, then could you please explain the motives for requesting recusal? January 22, 2026, I had an interview with the High Qualification Commission, second Kalechi, and based on that interview, I was deemed ineligible as a candidate for this competition due to personal incompetence. I got the decision on February 17th, 2026, and because of that, I didn't have enough time to challenge this decision, but I believe that because 2 members of High Qualification Commission voted for this decision, with the formulation of personal incompetence as per Article 100, they need to self-recuse because they already have bias against me, and it puts me into a discriminative position of discrimination. So this is brief content of my motion. And who should recuse? Sidorovich and Volkova, these members of the High Qualification Commission. Only those who voted for that decision to deem me as ineligible. Any questions, colleagues? Greetings, Irina. In your opinion, the results of your candidacy evaluation for this competition, for that competition, do they really impact the results of your evaluation in other competition? When one commission considers your profile, it doesn't mean that another commission will arrive at the same conclusions. Because the interview was carried out months ago, so actually my candidate's dossier includes this, and that was done not with the full commission present, but only with some colleagues present. I think it is necessary to do recusal. And one more question, building on your request. So in your court work, whenever the parties claim recusal, when you in the past made negative decisions against them, is it a satisfactory circumstance for us to recuse? So today, the criteria in both competitions are more or less the same, and the score was given a month.
Те саме моє суддівське досьє. У зв'язку з цим я вважаю, що є відповідні підстави.
Добре, дякую. Ще одне запитання. Скажіть, будь ласка, чи це є два тотожних конкурси?
Я вважаю, що у більшості критеріїв вони схожі. Звісно,
So the criteria are the same.
Вони не повністю тотожні.
So the criteria are not exactly similar.
Дякую, пані Ірина.
Thank you. Hi, Irina.
Критерії такі, як особистісна
The
компетентність.
criteria of personal competency, will it be there in this session today? So in this session today, I need to get a score as a candidate to proceed in the competition for the position of a judge. And that score includes the different aspects of my activities. Thank you. Could you give us some circumstances that that give you reason to believe that that decision was a biased one? In the first place is the wording that I got from the college, those members of the commission, and whether I get it right that your lack of consent is the reason for the recusal? Not exactly. Those commission members have already formed opinions about my personality, and that actually defeats the purpose of my participation in this interview now. So apart from the application that you submitted February 20, you did not submit any others? No. Thank you. No more questions. So following your logic, Ivasuk that member of the commission also has shaped an opinion about you. Why don't you request recusal from him? I stated the members of the commission who prepared the decision. I mean, all the three have certain opinion of you, and Vidasyuk can be biased too, but he voted in your favor. So the circumstance that I mentioned is the wording in the decision when the commission members voted against my participation.
У вас запитання?
Ruslan, do you have a question?
Пояснення. Ні, Михайло,
Maybe an
на
explanation.
мене питання. Це не питання, а пояснення.
So it's not a question, rather an explanation, still a
Можете в такому разі
an explanation.
надати пункт регламенту?
Could you remind us of the clause of the regulation that you refer to in your request?
На права головуючого я, звичайно.
So,
Та я на права головуючого, тому я його знімаю.
so I would like to remove this from the agenda as a chair. Any other questions? Colleagues from the Public Council of International Experts might have questions, so I could ask them. No questions. Robert?
Well, just have a look. Questions? Mary, questions on this? No, thank you, Chair.
Дякую. У Сергія Юрійовича було, будь ласка.
Я все ж таки хотів
Сергій.
запитати у
After all, I would like to ask a candidate about her position regarding the fact that during this meeting we are considering the same issues as during the meeting of the panel during the conduct of qualification evaluation. I think you've looked through the law, Part 4 of Article 8, about the purpose of the special joint meeting. If you looked through that, are you aware of that? Yes. Yes. A special joint meeting is held to study the matters of regarding criteria of integrity as well as practical skills and knowledge to consider cases in the jurisdiction of the Hague. The matter of personal social competence is not considered at all at this meeting. That's about a comment about your statement that it's the same as you had, because the purpose of this meeting is completely different. If you read the law, you should have seen that. Why are you stating that they are the same? That's in continuation of Roman's question. I believe that these indicators are included into the subject matter of examination during this joint special meeting. Okay, thank you. Your position is clear. Thank you. Now, if there are no other questions, maybe commission members would like to provide some explanations? No? We cannot force you. No? I can briefly express my position with respect to the fact that I do not consider myself to be biased, and any decisions adopted by me at specific point of time are based on those facts that existed back then. That's why I do not know the candidate personally. I have no biases regarding her. That's why I do not quite understand the justification. Thank you. Thank you. Okay. Then the commission moves on to the closed discussion of the matter and its resolution. So please, dear candidate, commission members, with respect to whom we are considering 2, 1.
Рішення прийнято. Слово
The decision has been taken. I am passing the floor to Roman Kodysyuk to announce our decision. I'm announcing it. The minutes decision, the first one. So, unanimously, we have decided to deny and satisfying application of Teslenko Iryna dated February 20th, 2026 on recusal of the HQCJ member Volkova Lyudmila Mykolaievna in connection with the absence of grounds set out by Part 1 of Article 100 of the Law of Ukraine on the Judiciary and Status of Judges. And the next one, also unanimously, we have decided to deny and satisfying application of Teslenko Iryna, dated February 20th of 2026, on recusal of the HQCJ member Sidorovich Ruslan Mikhailovich in connection with the absence of grounds set out by Part 1 of Article 100 of the Law of Ukraine on the Judiciary and Status of Judges. Thank you. Thank you. So let's continue our meeting. I'm drawing attention to fulfilling obligations set out by is back on in 3, 2, 1.
Дякую.
Thank you.
Звертаю увагу на дотримання.
I'm drawing attention to the need to adhere to obligations set out by the ROP of HQCJ.
Доповідачем цього питання.
The rapporteur regarding your candidacy is Kodysyuk Roman. Please, over to you, Roman.
Дякую ще раз.
Thank you. Good afternoon again.
Зараз буде
Now I will
невеличка доповідь
briefly
стосовно
present
вашого
your judicial dossier, Madam Irina, and then we will have the format of Q&A. Probably you've seen it, and it will not be different from any other candidate. So, candidate Teslenko Iryna Oleksandrivna is a judge. She submitted an application to the Commission on admission to the announced competition for the vacant position of the judge of the High Anti-Corruption Court. Percent results of the qualification exam, Teslenko got 351.85 points and was admitted to the second stage of the qualification evaluation, that is dossier examination and interview conduct. Qualification of the candidate. In 2002, she graduated from the National University of Internal Affairs and obtained higher education under specialty legal sciences and obtained the lawyer's qualification. In 2013, she graduated from National University Law Academy of Yaroslav Mudry and obtained full higher education and the legal sciences specialization, obtained the master's qualification. She does not have the academic degree. At the same time, she performed dissertation in Kharkiv National University of Internal Affairs according to educational program 081 law. The topic of her dissertation is admissibility as the popularity of evidence in criminal proceedings. She was teaching in the National School of Judges. The candidate has over 23 years of professional experience. Madam Irina had different experience of work, in particular as the individual entrepreneur, as a judge now. She's now a judge. She was also the head of the legal department, legal counsel, chief legal counselor, director and lawyer. With the decree of the President of Ukraine in September of 2016, Madam Teslenko was appointed to the position of the judge of Criminal District Court of Luhansk region for 5 years. And in 2024, she was appointed to this position indefinitely. With the decision of the President of the Supreme Court in October of 2022, Judge Teslenko was seconded to Solomiansky District Court of Kiev. So Teslenko has experience of working at the judicial position for over 9 years. She has not been brought to disciplinary liability. At the same time, there are complaints which were mostly considered and they are positive for the candidate in terms of their outcomes. That's it from my side, and I'm passing the floor to the chair. Thank you. Thank you, Roman. And I'm passing the floor to Mr. Robert. Robert, over to you.
Thank you, Mr. Chair. Please pass the floor to Norman, who is the rapporteur in this case.
Thank you. Good afternoon. I'm Mr. Teslenko. As introduced, my name is Norman Aas. I'm an attorney from Estonia and have worked also as a prosecutor. And congratulations for participating in this important competitions to High Anti-Corruption Court, and also congratulations to reach this joint meeting. Thank you. We have had already several rounds of questions and answers during the preliminary phase, but I will ask some of the questions again, because this is the public interview, and for the sake of transparency, it's important that also the general public will be aware of the issues what is covered already in the written questions and answers. But I like to start with your motivation and previous experiences. I see from your bio that you have served as judge for almost 10 years. Can you explain briefly what type of cases you have handled so far, civil cases, criminal cases, and what type of criminal cases you have?
Доброго дня, дякую.
Good afternoon. Thank you. I have worked in Luhansk region without specialization. During that period of time, I was considering all categories of cases, including civil, administrative, and criminal cases, and cases on administrative offenses. In my proceedings, I had different types of criminal cases. Mostly these were cases about criminal offenses against health and life and property, but I also had some corruption cases. However, I did not have time to bring the cases to the verdict because of the expiration of that 5-year term for which I was initially appointed. With respect to cases on administrative offenses, I adopted rulings for the violation of the anti-corruption legislation as set out by the Code of Ukraine on administrative offenses. Right now, I'm seconded to Solomyansky District Court of Kiev. I'm an investigative judge. On the territory of Solomyansky District, as I've mentioned, there are several pre-trial investigation bodies, and accordingly, I perform judicial control as investigative judge under all cases of these pre-trial investigation bodies based on their motions, complaints, including the ones related to corruption. Moreover, right now, I'm the judge of civil jurisdiction. I'm also considering civil cases. I'm also considering administrative cases in the jurisdiction of local courts. And I'm also considering cases on administrative offenses related to the violation of customs clearance rules. That's a few words about my judicial career. Besides, in the National School of Judges, I was responsible for criminal process. Mostly, my trainings and academic activities were related to matters of criminal process. I've mentioned I'm the co-author of the 1 chapters of the manual for investigative judges. We were also preparing trainings, and I taught within the framework of a criminal process and those matters that were included into the curricula.
Thank you. You have referred some of the corruption cases. If it's public already, can you mention what kind of corruption cases or proceedings were most complex or severe in your practice?
У мене було декілька
In my
достатньо
practice, I had quite a few quite challenging cases in the Luhansk region, but as of now, all criminal proceedings and procedural documents that I have adopted, they are blocked for public access. And that's why I think that I have no right to share this information for general audience. And regarding the work that I have been performing right now in District Court of the city of Kiev, I also have adopted so many different rulings, and many of them are now blocked for public access in order to take measures and ensure pre-trial investigation and also for the sake of national security.
Thank you. You are at the moment trying for the position of the judge in The Hague. What do you think, in your view, what is the difference between administrative justice in the general local court, as you working now as a judge, and in this specialized anti-corruption court? What's the difference, in your opinion?
First of all, that's about opportunity to focus at certain issues, as that's a specialized court, and it gives one an opportunity to deepen their knowledge, to work on specific practice and focusing at certain issues, certain corpus delicti. And to my opinion, in any case, it will lead to higher efficiency of one's work. Right now, in fact, I have been carrying out proceedings at all 4 processes, all immediately in parallel, and it's quite hard to maintain appropriate level of your professionalism at all areas. So, correspondingly, high anti-corruption court will allow me to focus at certain issues in order to ensure the highest level of administering of justice. And also, I can say, as a trainer, when we prepare certain activities for judges, very often it happens that we use specifically practice and doctrine of high anti-corruption court, because there are quite a lot of interesting cases considered by The Hague, and using those cases we can show different measures and different tools that shall be applied by a judge in certain situations. For example, let's take abuse of procedural rights. Correspondingly, this court is the one who creates certain novelties in criminal process, and it promotes, it leads the criminal process developments further. That's why I would be interested to join work specifically at this court.
Thank you. Beginning of this interview, you have brought our attention to the decision of the High Qualification Commission of Judges from 22 of January this year. Of course, we are not in the positions to assess this decision, but we like to understand more the underlying issue of that decisions. And I have read that, and this document refers to some proceeding happened 2019. And according to this decision, you explained that this process was somehow manipulated by the parties, what caused your self-recusal. Can you explain a bit more about this proceeding 2019? What happened there? Why you think that this process was manipulated by the parties?
Thank you for your question. Indeed, there was a corruption case
8 обвинуваченими.
There were two accused persons. They arranged a crime group, if I'm not mistaken. Is that criminal proceeding? In the first court hearing, the defendant's attorney submitted a motion to close a criminal proceeding. During consideration of that motion, I adopted the ruling to deny and closing that criminal proceeding. And the next step, which was taken by the defendant's attorney, they submitted a recusal motion because the registration of the law enforcement authorities happened at the entry. So they registered, they saw how law enforcement authorities came to my office at the court. So I didn't see that motion because I requested to provide me with a copy of that motion for recusal from the side of the defendant's attorney, but I was denied. I was looking into detail of that motion. That's why I saw only the result. So the ruling adopted by another judge with which that judge satisfied that motion. So that's like a post factum event that I saw, and that's why I didn't have some opportunity to respond. And the decision, the conclusion of the HCJ that I needed to submit an information to HCJ regarding the attempt to interfere into administration of justice by mine. I would like to mention that at that moment I didn't see such grounds for such submitting such notification because the defendant, whose attorney who submitted a motion for recusal, he used the formal right envisaged by the Criminal Code of Ukraine, and the judge who considered that motion adopted the relevant ruling within his discretion competences. And from the moment of adoption of that ruling, it became effective. And according to the law of Ukraine on judiciary and status of judges, such rulings shall be obligatory for its fulfillment, and everyone shall treat with respect such ruling. And that's why I didn't inform the High Council of Justice, because I didn't see there are any relevant grounds to inform the HCJ, but I took other measures. I sent letters to clarify the details of the story, why it happened, and because the wording which was provided there in that ruling, to my opinion, influenced on my name. That's why I sent relevant requests to the judiciary guard service in order to clarify how registration took place of those coming into the court and my office. I clarified that the procedure was violated of registration of all newcomers and guests, and measures were taken to correct such procedure in order to avoid such situations in future and avoid any potential manipulation of the participants to the process in order to de facto for them to successfully avoid consideration of such criminal proceeding.
Thank you. I'm a bit confused because I'm not aware of the speciality of Ukrainian law, but understood I correctly that actually this motion to recuse was made by another judge?
No, the motion on recusal is considered by another judge. According to the automized distribution system, so another judge is assigned to consider this motion. So not me as the judge regarding whom this motion was submitted, but another judge considered it.
Okay. Thank you. Let's go further about the next topic, and I have a couple of questions about your residence in Kremlina District Court during the administration of justice. And according to the PO 2016 to 2020, you administrated justice at the Kremlina District Court of Luhansk region. And we understand that you were partially absent from work during this period because of your childbirth, but during the time you were actively working there. Can you remember how many days per week you were usually physically present at that courthouse?
5 днів на тиждень.
5 days per
Понеділка
week
по
from
п'ятницю.
Monday to Friday.
And you were physically there, not over the video or something like that?
Yes.
It's basically every business day, except the vacation and of course other.
Yes.
And according to the declarations, you didn't have any declared real estate or any apartment to use in that period. So my question is, at which locations did you typically reside overnight during those business days? You stayed at Kremlina or?
Ні, я залишалась там.
Yes, indeed, I stayed there. If I may, I will go year by year to give you complete understanding. So back in 2016, I was appointed as a judge and I was included into the staffing list of judges into that court, and I took the oath in December 2016. It means that correspondingly, since that moment, I only started receiving cases for my consideration, and I was not fully engaged into the working process during that period. And during that period, I either stayed at the hotel, which is located nearby to the court, or I just took daily rent of an apartment. So it was possible to have a day rent for an apartment. I always went there on Sunday evening or Monday morning, and then full working week I was there. And Friday, I went Kremlina to go back home for a weekend. And then in 2016, I was, so in 31st December 2016, I was staying at home in Kharkiv. And according to provisions of legislation, we shall declare either place which was under usage or ownership as of the last day of ownership, or more than 180 days. So for 2016, I didn't have such property in usage. Regarding the next year, 2017, correspondingly, the situation was the same. So I was commuting to work. So I was spending the whole working week, and then I went back home only for a weekend. But at the same time, I didn't have any property in usage for more than 180 days because I needed to travel all the time. Kharkiv, I was pregnant, my husband was there, I needed to visit doctors, and so I realized that I don't need to rent out apartments there because I'm going to be on maternity leave, and that maternity leave actually started in August. It means that the daily rent, so daily rental apartments were offered for like a week rent, but they didn't rent it out for permanent usage. Unfortunately, I cannot provide the PCA members with any proving documents because, first of all, a long time has already passed, and secondly, last time at Kremlina, I have visited my office at the court one day before the full-scale invasion, and then I went to Kharkiv, and I had no opportunity to go back to Kremlina because of it. And all documents that were mainly related to my work are there in Kremlina settlement, and I have no access to them at all. Then, so it's but going back to 2017, again, there were some sick leaves, and because I needed to be under medical supervision in Kharkiv. Then, in August 2017, I already took the maternity leave, so in order to give birth. And as of 31st December 2017, I was in Kharkiv and under my place of registration. And that means that for 2017, I didn't have any real estate objects that I needed to declare according to provisions of legislation. Then, the next year, 2018-2019, I was on leave to take care after a child at my place of residence, even despite of the fact that formally I kept being a judge of the Criminal District Court of Lugansk region. But at that territory, I didn't have any properties to declare because physically I was not there in 2018-2019. Then, 2020s, I returned back to work. It was February 2020. But during that year, I was looking constantly for permanent accommodations. There were some apartments which I rented, but for not long period of time, for 2-3 months, because in small settlements, it's quite hard to find accommodation which will serve my needs, including one of such needs is for children to stay there, for my child to stay there. It means that during 2020s, I didn't declare any property, but of course, I didn't go to work and back each day. No, I had spending there my working days at my place of work, but under understanding of provisions of the specialized law, I didn't have properties to declare because I didn't use it for any kind of property for more than 180 days. And my all social connections have been related to Kharkiv. I didn't myself, I didn't see any plans and perspectives for myself to relocate to Crimea. But in 2021, I managed to find the relevant department, which indeed satisfied me. I concluded a renting agreement. Since that moment, I started declaring it. It was my permanent place of residence.
Thank you for your answer. I have a couple of clarifying questions regarding 2016 and 2017. What was your permanent or actual place of residence? Kharkiv? That time?
Харків. Хорошево, Харківський район та адреса.
So, yeah, that's Horoshovo, Kharkiv region, the place of registration.
Okay. And how far this actual place of residence was from this Criminal District Court, approximately? We are not aware of the distance in Ukraine.
Я вказувала в
Yeah,
поясненні.
I've indicated it in my explanation. That's 220 kilometers, something like this.
And for commuting, have you used your personal car or some public transportation back and forth?
Автомобілем.
Vehicle.
Your personal.
Так.
Okay.
Yes.
And can you remember, you have explained that during those business days you have stayed at the hotels and short-term accommodations. Can you remember what was the average price per night during those days?
Зараз складно згадати.
Now it's hard to recall. I think that it was something about 150-200 hryvnia per day, but I could be mistaken. I tried to find this information in order to provide it to the Commission. So I looked for this hotel at the internet because it's located like 200 meters away from the court building. But the settlement is so small that, it was not even publicly available, this information at the internet. But the range of prices was roughly like this.
And can you remember, paid you with transfer of the card or with cash?
So
regarding the fuel for vehicle, I think it was a bank card that I paid. I always use bank cards to refill my vehicle. All my cars usually have a gas fuel option. That's specifically because of this my need to travel for long distances. That's why all vehicles that I owned had a gas fuel option because it's cheaper.
My question was about paying for the short-term rent to the hotel. It was paid by the cash or credit card.
Ну, так. Щодо квартир.
So regarding apartments, yeah, definitely it was in cash because it's a small settlement and mainly cash payments prevail. Regarding hotel payments, I can't remember right now, but I think that, yeah, it was always also in cash, but they provided me with certain underlying documents, supporting documents, but I don't have them right now in order to provide it to the PCA.
Thank you. The next topic is related to your savings and expenses in 2019. And I understood that in that year you were on maternity leave. And according to the declarations, your family total declared annual income this year was 335,000 hryvnias, which is approximately $30,000 US. But in the same year, your family bought a car, Toyota Rav4, for 100,000 hryvnias, and your saving risen approximately $7,000 US, and although also all the everyday living spendings. But so we'd like to understand more your family income structure this year, as you was in the maternity leave, how your family could afford this car and also accumulate $7,000 US as savings in the same year.
Я надавала в своїх
I have
письмових
provided
поясненнях,
my
що
written explanations that saving, that's what actually was available at the end of 2018, but only savings were in cash and they were transferred into USD dollars. So if you look, and actually this was the amount of $10,000 that was declared by me back in 2019. Purchase of that vehicle, it was purchased which at the expense of partially at the expense of alienation of my previous vehicle, and it was also declared. All other pieces of income have been declared in my declarations. Regarding expenses, I have already provided information, and that you have only calculated so everything related to very basic needs like utility payments and food, taking care of children. So regarding utility bills, I only managed to find certain receipts and bills for 2017, and I provided it already to the Commission. But it's more for you to understand the range of expenses family which resides at the private house. At that moment, during that time, we had lived at a private house, and means that in terms of utilities, we had only to pay for electricity and for gas supply. I provided a range of different prices for utilities and provided also as confirmation those bills for the previous years that I had found and received and shared with you. There were no significant expenses, no traveling during that period of time for my family. Major part of time I spent at home, because you know when you have two children, so it's actually twins of such small age, you cannot allow yourself to go out somewhere. I didn't buy anything for me. I didn't buy any clothing or any new things. And regarding the taking care after my children, of course, during that period of time, parents helped us, parents helped their own grandparents. The Commission also asked the volume of such help, but you know, it's hard to answer because it was just average, ordinary help of grandparents to their grandchildren. Some things were bought for children, maybe vitamins, some food was bought. So specifically something.
Thank you. The next question is about your cars. According to the declarations, you had several cars, and what is interesting for us is that there are some sort of pattern that your family has bought a car, and a couple of years later, those cars were sold, but much higher price as was the initial price, and most remarkable example for that is Toyota RAV4 bought in 2019 for 100,000 hryvnias, and 3 years later your family sold this car for 300 hryvnias, and even taking into account this inflation and the changing of rates, it seems to be quite high price, and even calculating it in dollars, for example, the price has almost doubled during 3 years. Can you explain what was the reasons or what was the objective circumstances that you managed to sell this car much higher price?
Я не займалась саме купівлею.
I was not
і
involved
ремонтом
in
транспортних
purchase
засобів.
and
Це
repairs
мали
of cars.
чоловік.
That was done by my
Наскільки
husband,
мені
to my
відомо,
knowledge.
була потреба в
But this
повному
particular car,
перефарбуванні, оскільки
that
вона
car
мала
needed
якісь
to be
пошкодження саме
repainted,
фарби. Я не є спеціалістом.
refurnished. I'm not a
То
specialist
мені важко сказати, що
in
саме
cars,
було з
so
нею
it's really
не так.
hard for me to say what was done to it in particular. I knew that it required some kind of repairs and painting that impacted its price. And further on, my husband dealt with it. He repaired it, and it was completely repaired.
Він займався цим самостійно.
And my husband did it on his own. And when I sold it myself,
вона також була продана дешевше,
that car
ніж ті автівки,
was
які
sold
були по
cheaper
ринку.
than the
Внаслідок
cars
того,
in
що
the
вона
market.
теж
Why?
одним з
Because
критеріїв все одно там не
following some
відповідала
criteria, it was
високому
not
рівню. То я
relevant
хочу
to
звернути
the some
увагу, що
high
це автівка,
quality
яка
standard.
коштує
So
4-6
that car,
тисяч доларів. Це не якась коштовна машина.
this car costs from $4,000 to $6,000. It's not something I could really earn money on. It was just a regular car that I had at hand, and its technical features impacted the price. And I cannot give you the exact technical characteristics now because I wasn't involved in this myself.
Was this Toyota RAV4 the same car what you used to commute between the courthouse and your permanent place of residence? Have you used this car as well? Car to go to the Kremlin?
Так.
Yes.
I can imagine that this instance was quite long, back and forth, more than 400 kilometers. That this usage of car was quite heavy. So this is I'm wondering how this price rises so much. But the last questions about those cars, as I mentioned, according to the declarations, The same happened with the other two cars as well, and altogether, your late husband made a profit almost $7,400 selling those cars with higher prices. And was this some sort of entrepreneurial activities your late husband, or repairing the cars and then selling it later at a higher price? Because it happened several times, quite a small gap of the time during 4 years.
Я не вважаю це підприємницькою діяльністю.
I don't believe this is entrepreneurial activity because usually we would change cars no more often than once per year. And my husband would look for cheaper cars. In Ukraine, it depends on where the car is sold. If it's in Kyiv or Kharkiv, it's going to be more expensive. If it's in other town or city where you need to go, the price will be better. So he would look for cars he could buy at a cheaper price. Then he would repair them. And then for our own usage, we would use them for some time, for a year or a year and a half. Then we would sell them as long as they were in good shape and we didn't need to do anything about them. So it was not a systematic activity to earn money, to make profit. It was about searching a better car for personal usage within our budget. So my husband would look for cheaper options that could be improved and then used.
And you answered that your late husband repaired those cars by himself. What was the professions of your late husband?
Він був колишній співробітник
He
правоохоронного
used to be a law enforcement officer. Then he was on pension. And then he used to be a security officer in private companies.
Okay, thank you. The next question is related to the mortgage. According to the declarations, on 2006, you acquired ownership of a residential house and the land plot. And to purchase that, you took a loan from the bank. And you repaid this mortgage 2015. And the balance of this mortgage was that time $20,000 US. Can you explain what funds were used to repay this loan earlier? This $20,000.
Вона сплачувалась протягом певного
So it was paid within a certain period of time. We purchased in 2006 and we paid it by 2015. And we used the money that my husband had from selling his apartment.
And this repayment was made as one transaction or as installments? It's 2015.
I'm sorry. Would you?
Yes, I repeat. I understood that 2015 the full mortgage was repaid and the balance was $20,000. And my question is, was this balance or this remaining amount paid as a one transaction, so one transfer?
Ні, вона постійно сплачувала
So we have been repaying that mortgage since we started it, since 2006 until 2015, and in 2015 it was repaid early, and the bank agreed with us on this sum, and I don't remember the exact sum, but the bank, because the dollar rose quickly, they could reduce the debt, and they enabled us to repay it in one transaction, the remaining sum. We could repay the remaining sum in one transaction, but we started repaying it monthly from the moment we started the mortgage throughout 9 years.
Yes, thank you. The next question is about the cars, Volkswagen Touran. According to your 2021 declaration, you jointly own two Volkswagen Tourans. One is 2010, acquired in 2018, and the second one is acquired on 2021. So I just like to ask, is this some sort of a mistake, or you really own two similar cars, those Volkswagen Tourans?
Ні, це було майно.
No, it was property that we owned together with my husband, and when he died, I needed to take some steps to inherit the property. And we inherited, my kids and myself, we inherited this property in small parts, and I declared every step that I took in order to inherit the property. And this is why it looks so complicated in the declaration, because it was indeed a complicated operation, and I tried to reflect it as to the fullest extent in my declaration.
But this was only one car.
Так.
Okay.
Так? Yes.
Про Volkswagen, так?
About Volkswagen. You're talking about Volkswagen.
Так, це одна і
Are
та
you?
сама автівка. Так.
Yes, exactly.
Yes. Mm-hmm.
So, thank you very much. My 40 minutes has passed quickly, but I'm exactly on time. Thank you.
Thank you. Questions on this side? Mary? No? Back to you, Mr. Chairman.
Будь ласка, Роман Анатолійович, тоді вам надається слово.
And
Дякую.
please, Roman, you have the floor. Irina,
Маю декілька запитань.
I've got a couple of questions
Сфер стосуються. Тим не менше,
about different areas.
для вас сенситивні, або
But
такі,
some
які ви
questions
вважаєте,
may be
що
sensitive to you, and if they are sensitive and they should not be public, so you think, then we can talk about it in the closed session. Let us know. So, number one is motivation. In your motivation letter, you state that your activities in symbiosis or professional activities in private and public sectors gives you certain advantage to deal with the cases
куди ви кандидуєте.
of the hack.
Все-таки чим відрізняється ваша мотивація бути суддею ВАКС?
What's the difference between your motivation to be the hack judge and to be an appellate court judge, where you also participated as a candidate? candidate. So when I entered the competition, I didn't really have a clear vision of who I would like to be, what kind of cases I would like to have, criminal cases or civil cases, because all the four processes stay with me during my tenure as a judge. In Solomensky court, this specialization is not that obvious, but at the same time, I do both civil and criminal cases. And when I ran for the appellate court judge, I was supposed to have civil cases. Regarding the high anti-corruption court, currently, all my interests are focused on criminal law, because in the National Judges School, I work mostly as a criminal judge, and I study criminal law as an academician. I have my PhD degree in this area, and my articles also pertain to this area. So my motivation to be the Hague judge lies in the fact that it is a possibility for me to focus on the criminal proceedings, criminal laws, and criminal offenses, so that I can ensure the high efficacy of my work. And I could also develop as an academician. I could process new information, new ideas for upcoming scientific research. Thank you. Then let's move on to your professional life, interference with justice. So you stated the interference with judges' activities back in Kiev court from October 24 to May 25. So the workload was higher there, and the possibilities to exert pressure on the judge also higher. Is it a coincidence that within the last years you started stating that? Well, before I didn't have such cases. In Luhansk Oblast, third parties did not have access to my office, and I met the parties exclusively during the court sessions. In Kyiv, unfortunately, our work is structured like this. Anyone can enter the judge's office. And my first notification or report about interference pertained to the fact when an individual entered my office, started threatening me, tried to influence my decision. He told me that he had turned to certain law enforcement bodies, that he was collecting information against me, and therefore I turned to the High Council of Justice and the Office of Prosecutor General and informed them of that. The latter passed my claim to the prosecutor's office in Kyiv Oblast, and they informed me that they included, it registered this case in the Unified Register. From then on, that individual did not turn up anymore. And could you comment on the second case? Then pre-trial summoned me for a interview regarding the claimant, because a criminal case was registered against me, and I was surprised by that because it was a claim against me in the context of the qualification test. And I believed that it was done in order to further influence me as a judge, to influence my professional activities, and this is why I turned to the High Council of Justice and the Office of Prosecutor General. Are you aware that in case you're elected as the Hague judge, the number and scale of such interferences could increase? What would you do to face them? I'm aware of this, and I believe the judges must oppose them and defend their independence. And in case there are circumstances, I need to turn to the High Council of Justice, and the Office of the Prosecutor General could also respond to such cases. Thank you. Regarding your disciplinary complaints, they were mostly denied, and URP still considers the complaints of Rybalka Chuchkovsky. Do you have any updates? Were you summoned for a session? I was not summoned for a session. And regarding the second case, I think I've seen somewhere on the internet that the case was closed because it wasn't the agenda, the High Council of Justice agenda, but I cannot give you more information now. It seems like that complaint was closed. And regarding Rybalko, I had two cases. They have been considered. And in terms of disciplinary complaint, I provided explanations to the inspector, but I have not been informed of anything else. All right, then next questions will be related to your participation as a member of the Partia Regionів, the Party of Regions. You have been a member of this party for 2 years, political party. What did you take away from this experience? Nothing, because I did not take an active participation there. I just couldn't. And when I joined it, I hoped that I could make a difference in this country, but it didn't happen, and therefore I exited this political party. But this is a fact, and I cannot conceal it. But it didn't really affect my activities. Is my understanding correct that it was since 2010 to 2012? Not 12, even earlier. I exited earlier because I submitted documents in the competition to be appointed as judge, and by the time I had exited the party, but I don't remember the date. So the period of my belonging there was really short, even less than 2 years. Do you believe that you are equally distant from all the political parties? Could you maintain your political neutrality? Yes, I do believe so. Then you are an NGO co-founder, NGO Gest. Yes, before my appointment, I operated in an NGO that helped citizens to protect their rights. We would prepare applications, and I don't see any harm in this. And that NGO was not related to any political party. It was that NGO was registered in order to help
Тоді
people.
рухаємося далі. Ще питання по фінансу.
Then
Питання, скажімо так,
some
в
financial
декларації ви
issues.
декларуєте повернення з державного бюджету 24 тисячі гривень. Що це? Це надмірно сплачені податки?
That is excessively paid taxes by you for life insurance, or that is compensation for tuition? Yes, that's compensation of tax from individuals' tax envisioned by the tax code in connection with the payment of my tuition and then my children's tuition. Every year, I'm submitting my declaration to the tax body, yes, according to the requirements of the tax code.
Дякую. Тоді
Thank you.
будь ласка,
Please comment then.
Квартира, Харків, 2020.
Apartment Kharkiv 2020. What was the reason for such a low price of the apartment? During the conduct of the qualification evaluation, I provided what I could provide back then. That was the consultation of the evaluator, who confirmed that it was the real value. That agreement was concluded with a seller. The agreement has also been provided to confirm the vehicle. The transaction was made through a non-cash manner, so that was a transfer of funds. It was without repair works. Subsequently, those repair works were completed. I've sent to the PCAE emails, printouts from my bank account, where you calculate the amounts that were withdrawn from the account, because all the funds throughout 2020-2021 were transferred by me in order to repair this apartment. Tell me, please, according to the declaration, you are also declaring cash assets. And actually, starting from 2021, as contrary to 2020, you have an increase in financial assets by $20,000. Tell us, please, what was the source of origin for the accumulation of these assets, given the fact that in 2020 you were buying an apartment in Kharkiv? With respect to cash savings, I have prepared a table with calculations about sources. First of all, there was a difference between the sold house and the bought apartment, quite a significant amount. Subsequently, also a vehicle, Volkswagen, was sold, with respect to which Mr. Norman asked. That was the second vehicle after the death of my husband. I sold it. If I'm not mistaken, that was the equivalent of $6,500, something like that. Besides from current savings, and I was also buying dollars that were placed at deposit accounts. The full calculation for that period of time as to how these funds were accumulated have been provided by me in writing.
Дякую.
Okay, thank you.
Наступне тоді питання.
My next question is then about
Вас і родини більше.
you and your family more. In 2020, according to the court decision, you divorced your husband, correct?
Як
Yes.
ви можете прокоментувати?
How can you comment
що після розірвання шлюбу
on the fact that after the divorce, you issued to your husband issued powers of attorney to you? What was the reason for that, and how you can comment on that? First of all, we were issuing powers of attorney to each other regarding the possibility to get financial assets in the bank, because $10,000 that were our savings were divided by us in half after the sale of the house, and we placed them with a deposit account. And in order to have a possibility to get them, if necessary, in particular during the conduct of repair works, for example, we issued these mutual powers of attorneys, because actually these were joint funds. And since the deposit was in Kharkiv, when I was actually working in Luhansk region, it was very difficult to withdraw this money from the account when necessary. That's why I issued this power of attorney to him. Also, during the repair works in the apartment, I needed help with the resolution of issues related to this apartment, and that's why I also issued the power of Estonia in his name, and he was helping us because we needed to furnish this apartment, and I was going to work to Luhansk region with 2 children, and that was very difficult to do on my own.
Дякую.
Thank you. Tell me, please, do you keep in touch with a father and sister? Yes.
Як ви можете
How can you describe this relationship? Well, I communicate with my father and sister. Right now, they are in Germany. My sister went abroad in 2022 after the start of the full-scale invasion. My father went there somewhere, I think a year and a half ago. So we call each other sometimes, but that's not on a daily basis.
Дякую.
Okay, thank you. What about your aunt? Because you mentioned her a lot as well. I do not keep in touch with other relatives. My father has 2 sisters, and I do not keep in touch with any of them for a long period of time. Now, with respect to the border crossing with the Russian Federation, I would like to ask you. You crossed the border and you were in the Russian Federation, as you are saying, because of urgent necessity. Can you please tell what was this urgent necessity? There are 2 border crossings, one in 2014, the other one in 2016. I would like to point out that in any case, that was before I was appointed to the position of the judge. In 2016, you can see that from dates of border crossings, these were for 2 days because there was a need to take medications that my parents needed. So one day was travel there, one day travel back. With respect to 2014, that was a flight from the airport in Belgorod that unfortunately is located not far from Kharkiv. That was a gift from my husband, and I had a transit travel through Russia, yes. Which mode of transportation did you use in this urgent necessity situation? I was crossing by foot. Then I was got into Belgorod. There I bought tickets for a bus and I was going further. And what was the town that I was in? Moscow. Okay, thank you. Colleagues, mostly I've asked all of my questions. The PCIe has shared with us an appeal regarding Teslenko from ANTAC Center and from Transparency International. Mostly we've raised all of these issues, so there is no point to repeat them. At the same time, there is another complaint which we actually received a couple of days ago. And since we received it to the address of the Commission, I have to ask this question and I will ask the judge to comment that. Madam Iryna, do you know about such complainant as Bukharov? I cannot recall that person, but in my proceeding right now I have about 1,000 cases, so I cannot remember all of them. Actually, the complaint is about the disciplinary offense of the judge. That's not in the jurisdiction of the Commission, but still, I will just comment on that because we received that as a Commission. Complaining of the disciplinary offense on the 24th of April of 2024 was notified of committing a criminal offense. We are talking about the situation under which the judge was considering the case. That's why I would like to ask you whether this case has already been considered, so that doesn't happen that we are asking about this circumstance that maybe you still have in your proceedings. As far as I understand that we are talking about specific case that I heard as an investigative judge. Right now, I cannot recall proceedings with this person with this surname. So I cannot tell you whether it has been considered, because as investigative judge, I considered 800 case materials in a year and a half. I cannot physically remember all the surnames of those persons who are complainants or with respect to whom motions were submitted.
Ну, зокрема, скаржник
In particular, the complainant
наводить
is
обставини і кваліфікує як
talking
безпідставне
about
затягування
circumstances
судових щодо
and says that the judge unreasonably delayed consideration of the case within the term envisioned by the law.
Вам невідомо або ви не
You do not know or you do not remember about this participant of the proceeding? No, I don't remember. If you could at least tell me about the essence of the complaint or something that could help me identify the case and when I had it. Because, for example, in April of last year, in my proceedings, I received 70 materials of cases and investigative judge simultaneously. So it's a very large volume on a daily basis. So I cannot remember all of them. Maybe you can at least say regarding which matter he submitted his complaint. Maybe then somehow I could identify this person. Okay. The Commission will assess it in terms of its acceptability, because the complaint itself is more about the High Council of Justice rather than the activities of the HQCJ. Okay, thank you. Colleagues, that's it from my side. I've asked all the questions that I wanted to ask. Colleagues, do we have any questions to the candidate? Ruslan first. Yes, if possible, just for us to finalize. I don't know whether my colleagues will have questions about property, but I would like for us to finish this matter because it's somehow unclear about the value of the apartment that you bought, right? You referred to the fact that I understand that you do not have any other documents, but you referred to such a document as consultation on property valuation. Do we understand it correctly that that is the only document that you are using to explain the price at which you bought this apartment? When I was completing qualification evaluation and this matter was raised for the first time, I addressed the valuation entity to ask whether they could assess my apartment as of the moment of its purchase so that I would have a chance to prove the adequacy of their purchase price. They explained to me that since that happened some time ago and the apartment has already been repaired, so what he can do is to provide consultation as to how correspondent the price was to market conditions, which I did. Madam Iryna, I will clarify the question so that we would be as correct as possible as lawyers. Do you have any other documents that could show that this price is fair, apart from this consultation? Yes or no? Do you have any other documents? I've provided the agreement, the payment instruction for settlement, and this document, no other documents. Okay. I was just in case something exists and we do not see that. Okay. Now, tell me, please. You know, obviously, as a lawyer, as a professional judge, I'm not questioning that at all. So you know that there is a consultation regarding the determination of the price, and then the evaluator is not bearing any responsibility for expressed opinions. And there is another type of a document that is called Report on Valuation of Property. Inaccurate statements expressed by the evaluator in such a document as the report on valuation of property could entail such a consequence as the loss of license for the conduct of appraisal activities. And you are aware of that, of course. Undeniably, a period of time has passed. Let's assume back then you did not have the evaluator's report, but there is such an option as conduct of so-called retrospective analysis of the price. In this case, the evaluator can conduct retrospective price analysis and express opinion about the price of the property retrospectively in time. But if the evaluator makes any mistake during the conduct of such valuation, then this person can be brought to disciplinary responsibility. And obviously, the weight, the significance of that document is drastically different because, let's put it that way, a mistake of the evaluator in such instance can have a very heavy price for them, because I know that evaluators appreciate their licenses and it's not that easy to obtain them. So why didn't you order such a retrospective analysis as valuation, but rather you only requested consultation? First of all, the timeline was very short within which back then, during the qualification evaluation, I had to provide some evidence to confirm the fact that that was the real price. Moreover, physically, I'm not in the city of Kharkiv. I'm right now together with my children in the city of Kyiv. There is a problem to get to that object, to provide access to the object for the conduct of its survey. I was not in Kharkiv, and I have not been in Kharkiv for over 2 years now at all. So there was a problem with that as well, that I needed to go there to involve the evaluator who would inspect and examine the object, and they cannot do that in one day. Back then, I received the conclusion of the Public Integrity Council, as far as I remember, on the eve of the panel's meeting, and I had to urgently get some evidence. And in connection with that, with respect to this object, I got this consultation at the very least. There is comparative analysis with other real estate objects, and that confirms that the price was the market price. In this competition also, there were quite tight deadlines by which I had to provide some evidence. At the same time, I did not take annual leave on a daily basis. I'm at work, I'm administering justice, and accordingly, I was providing my responses to the PCA mostly in the evening or during the night, and so it was difficult to exercise that even. I can believe you, I understand the workload of judges in big courts. That's indeed quite a big workload. Solominsky court is the court overwhelmed with the workload. We consider it the possibility of secondment of judges to that court because we know about the huge workload. But you are pointing out that the comparative analysis was carried out, but again, as a judge, you cannot but know about the methods of the property valuation. That according to the law on the valuation activities, there are 3 main methods. Capitalization, cost-effective, and comparative methods. In your consultation, only one approach was used, that is comparative approach. And for the conduct of the analysis, only 4 objects were used without addition of references to those ads that were taken as the basis for comparison. I think they exist, but my question is the following. I do not question the accuracy of the price, but look, what's the matter? If we transfer that to the dollar equivalent, because hryvnia is going through devaluation because of different objective reasons, we have the object during the zero cycle from the construction company, and that's at the level of $360 per square meters. That's not an old BT. That's not a barrack type construction, and you're getting the conclusion that is based not even conclusions, but only consultation that is based exclusively on 4 objects without inspection on the spot, etc. Let's switch places. You are a judge. Now we are assessing accuracy of your statements, but recall that you are a judge in criminal, administrative cases, etc. But what is written evidence to you to confirm their positions? For you, would this evidence be enough or no? I'm just interested in your opinion as a judge. I'm always considering all the evidence into their totality that has been provided to me. What I have, what I can provide to the Commission, I'm genuinely trying to provide. That I cannot go back in time. I cannot go back to Kharkiv and to prepare the valuation report. Unfortunately, I've made conclusions for myself that if I'm selling or buying property, I will always at once prepare this revaluation report. So my question was slightly different. As a judge, for you, is this evidence sufficient? Or not really? I am accepting evidence in their totality, and I am considering the opportunity to prove in their totality. Let me rephrase my question, Madam Iryna. Please answer my question. Yes or no? Yes. This piece of evidence would be sufficient for you. Yes. Thank you. That's it. Okay, please. Good afternoon. A question as the author of the practical assignment. Do you remember the situation? Declaration of inaccurate information? I will try to recall. In the declaration for 2023 that was filed in March of 2024, the deputy of the regional council declared inaccurate information. As of the moment of declaration submission, there was a provision in effect in one version, but then during the court consideration, the provision was amendment. The fine was increased and the threshold of declaration was increased as well. In your practical assignments, you fully used the provision that was in effect as of the Act Commission. Can you please briefly describe the motivation? Why didn't you use the updated disposition? I was governed by the principle of retrospectivity and retrospective application of the law. That's why I was applying the law that was in effect as of the moment of the Criminal Offence Commission. Okay, when you are comparing two different criminal laws, how are you assessing favorability of these laws for the defendant? If it improves the situation of the person or if it cancels criminal liability, then accordingly it can be retrospectively applied. And my last question, if the old law criminalized the action starting from the threshold of 500 minimums, and the new law says that it should start from 750 minimums, then it was an improvement. Accordingly, the new provision should have been applied. Thank you. Colleagues? Ruslan, please. In continuation of this topic, if we are talking about the knowledge in the anti-corruption legislation, and my question is the following. Tell me, please, Commission Member Melnik, tell me, please, do you agree with the statement that for corruption offenses, there is envisioned only criminal liability? No, the criminal offense, corruption offense can, according to the law on corruption prevention, can entail criminal and disciplinary and civil legal responsibility. Great. Then tell me, please, or provide example when for committal of a corruption offense, in which instances a person may be brought to disciplinary responsibility for committal of corruption offenses, if there are no grounds for bringing this person to criminal responsibility, but there are signs of a disciplinary offense, and then the person can be brought to disciplinary liability. Yes, that's a general rule, or if the criminal offense is closed. Okay, that's according to the general rule. And my question is about the criminal offense. Can you provide examples of such offense when a person is not brought to criminal responsibility, but at the same time, this person can be brought to disciplinary liability for the same actions?
If
in the actions of the person there is no corpus delicti of the criminal offense, but at the same time the person has violated its official duties, then in any case it will entail disciplinary liability. Yes, but at the same time it should be a corruption offense. Do you have an example of such a corruption offense for which the person cannot be brought to criminal responsibility because of some circumstances, but the person can be brought to disciplinary liability? As an example, you've voiced general approaches. Maybe you can name an example of some corpus delicti of some specific offense. Quickly, it's difficult to make up such an example. Okay. And can you please tell me what is the distinction between corruption offenses with corruption-related offenses? Corruption-related offenses do not contain signs of corruption, but they violate requirements of the law regarding prohibitions established by the law on corruption prevention. If we are talking about the definition that is given in the law, or do you want the answer according to the criminal code? And what are the corruption-related offenses in the criminal code? That's intentional failure to submit a declaration or intentional concealment of information. Or if the discrepancies, I think, amount to over 250 substance minimums, if I'm not mistaken. Okay, thank you. Then, in continuation of this topic of skills, I would like to ask a question as well. Tell me, please, is always the violation of territorial jurisdiction rules a ground for recognition of the evidence as inadmissible? That's about the topic of your dissertation research. Can I clarify a bit then? The evidence gained as a result of what? Which particular pieces of evidence? You're a judge of the High Anti-Corruption Court, the presiding judge or a member of the panel of judges. You're considering a case. The defense party is submitting a motion. The evidence has been obtained by not appropriate pretrial investigation body that was supposed to conduct the pretrial investigation body. The rules of territorial jurisdiction have been violated, and in connection with that, all the evidence obtained is inadmissible according to Article 87 of the CPC. What is your opinion regarding that? Understood. That's the topic of my dissertation paper, because I believe, as an academic, first of all, that you cannot have a formal attitude towards inadmissibility of the evidence. It is necessary to look at the essence of the specific violation as to what it affected, whether you can trust the respective piece of evidence, and whether the trial process can be considered as fair with acceptance of this evidence. Because in any criminal proceeding, apart from the defendant charged with the committal of the criminal offense, there is also the consideration of the society's interest. Now you're describing the motivation part. I'm against formal approach in any case. In my court hearings, defense attorneys or make up new and new circumstances in order to recognize the evidence as inadmissible or obviously inadmissible. And I'm always justifying my position. I'm referring to what it entailed, what were the implications of that, whether this evidence has been distorted as a result of the respective violation, what was the impact of that violation, which rights of the defendant were affected by that. And as a result of this comprehensive consideration of issues, then I'm taking the respective decision. But the formal approach that if there is any violation, the evidence should be recognized as inadmissible, no, I disagree that it should happen like that. Okay, clear. And should the Anti-Corruption Court check lawfulness of decision-making by the Security and Defense Council on imposition of sanctions in the form of blocking of assets during the consideration of the so-called sanction case? In my opinion, the Anti-Corruption Court applies consequences as set out by the law on sanctions, and as the decision itself, it's not being checked. It can be the subject matter of challenge, but in another process. The decision is not checked by the Anti-Corruption Court, right? The lawfulness of the decision. Lawfulness of the decision. I'm trying to recall provisions of the Code of Judiciary Proceedings, but I do not remember such a requirement from that article. But I might be mistaken because until now I have not had in my caseload such cases. You're a candidate to the Anti-Corruption Court. That's why I'm asking about these cases, because they are considered. Thank you for your answers. So, Halina, you had a question, please. Thank you.
Thank you. One more question. You did not answer directly. So after 2014, when Russia annexed Crimea and another certain part of territory of Ukraine, why would you visit Moscow in 2016 when you were a judge? I was not a judge back then, and I explained that I needed to collect medicine for my parents, and no one else could go. It was a 2-day trip. And was this medicine produced in Moscow? Couldn't you get it otherwise? Only there. So do you believe that that was an urgent need? Yes, I do. Thank you. One more question. As you're saying your relatives are in Germany, it was in 2024. And where did they set out? From Ukraine, from Kharkiv. They were not on the non-governmentally controlled area even once. No more questions, colleagues. Irina, then within a minute, please state what you haven't had time to state. Something about yourself or some facts that have not been mentioned yet. Thank you. Thank you. In the first place, I would like to add that my position is accurate and clear. I'm a patriot. And since 2016, I've been appointed a judge in Luhansk Oblast that was in the anti-terroristic operation area. And since then, I have considered cases related to occupation and the aggression. And that testifies to my pro-Ukrainian position. Today, I investigative judge dealing with cases related to the national security of Ukraine, and within the premises of my court, there is a pre-trial body, and these circumstances also testify to my being a conscientious citizen of Ukraine doing its best to approximate Ukraine's victory in this war. I would like to thank the High Qualification Commission, judges, and the Public Council of International Experts for the opportunity to go through this interview. I believe this is a very enriching experience for me. I'm glad that I reached this stage, and I believe that further on, this experience will come in handy. I would like to thank the Public Council of International Experts for finding time and possibility to join this competition procedure, for finding possibility to come to Ukraine in person despite the security climate. Thank you for taking part in the very important processes for this country. Thank you. The interview is complete. Thank you for your participation. Stay well. The issues put on the agenda for consideration today have been all considered, and the session